Hello, I'm Samantha Mobley. I'm a partner in the London office of Baker McKenzie. Today I'll be discussing steps recently taken by Europe's antitrust regulator, the European Commission, which suggest that investment funds and financial sponsors may be subject to increased scrutiny with regard to the anti-competitive behaviour of their portfolio companies. In January 2009, the Commission started investigating 12 companies involved in submarine and underground power cabling, which were alleged to have been involved in market sharing and price fixing activities. Goldman Sachs has confirmed that a portfolio company, which is no longer under its control, was one of the 12 that's under investigation. And it received a statement of objections, an initial charge sheet from the Commission setting out the allegations, on the basis that it was the controlling shareholder of the company at the time of the alleged infringement. It's not uncommon for the Commission to attribute liability to a parent company for breach of a subsidiary, even if the parent company had no knowledge of the violation and no longer controls the subsidiary. But this is one of the first times that a private equity company has been targeted. The Commission is sending a clear message that private equity companies must be committed to ensuring antitrust compliance within their portfolio. Given the size of the potential fines, the profitability of the investment may be impacted if they are not. The Commission can attribute liability to parent companies which exercise decisive influence over a subsidiary. Decisive influence is presumed where a parent owns 100% of a subsidiary. Although this is a rebuttable presumption, it's proven to be very difficult to dislodge the presumption in practice. Note that the Commission is not prevented from pursuing a parent company on the basis that it no longer owns the subsidiary that committed the alleged breach. A seller will almost invariably be held liable for the period in which it owned the infringing entity. So why would the Commission want to go after the parent company in this instance rather than restricting its focus to the portfolio company itself? Firstly, attributing liability to a parent company is an attractive option for the Commission, as it can impose a larger fine which may also stand a greater chance of being paid. The fine is larger simply because it's capped at 10% by reference to the turnover of the addressee of the statement of objections or the charge sheet, which is of course much higher when the parent company is brought into the frame as the addressee. There's also a greater chance of recidivism, i.e. repeat offending. This is because the parent company holds a number of portfolio companies and therefore the odds of earlier violations by at least one member of the portfolio are higher. Repeat offending enables the Commission to increase a fine by 100% for each prior infringement. Going after the parent company of a group also sends a much stronger message to the market. The Commission's reasons for going after Goldman Sachs in this instance have not been made public, and at this stage only a statement of objections has been issued. The statement of objections gives the parties a chance to comment on the Commission's findings and to make its defence case ahead of a formal decision. However, the fact that even a statement of objections has been issued sends a warning signal to private equity. It's a reminder that, like any other corporate group, private equity will need to ensure that antitrust compliance is taken seriously even within its own portfolio of companies. Indeed, the way private equity funds and business have traditionally been structured may make them particularly vulnerable to parent company liability exposure, since a management agreement between the parent and the portfolio company make it very difficult, if not impossible, to avoid the parental liability presumption. Fines can be severe, especially if the parent company is liable, and can have a negative impact on the fund's profitability. Further, cartel investigations usually depress the share price of companies under investigation, at least for a while. It's not impossible that private equity company could be sued by investors for failing to take adequate measures to prevent antitrust infringements, for example, through implementing and enforcing a genuine antitrust compliance culture. In any event, reputational damage arises from being thrust into the spotlight. So what should private equity funds do to reduce the risk? It's critical that antitrust compliance is an important element of the overall deal strategy. At the pre-approach phase, the target's risk profile should be investigated by risk markets, both product and geographic. This will impact on the deal value and indeed could influence whether to bid at all. During due diligence, that risk profile should be tested by assessing what compliance programs exist, how they're implemented, and how they're checked for effectiveness. Any areas of concern may be carved out from the deal or risk mitigated through contractual protection. But despite best efforts, it can't be assumed that compliance problems will be identified pre-acquisition. Antitrust issues can reside deeply within an organization and may only come to light sometime later. Contractual protection will have its limitations, for example because the seller was unaware or due to the passage of time before the infringement is identified. For that reason, private equity companies need to consider more effective means of unearthing illegal conduct immediately following acquisition. There are many ways of doing this, such as an audit including interviews and document review, and through regular compliance training. Where more serious and/or more deep-rooted violations are suspected, an antitrust amnesty program may be advisable. Where a company's otherwise strict disciplinary policy may be relaxed for a limited period to encourage employees to self-report antitrust violations within the organization. Such amnesties need to be designed and implemented carefully as they touch on a number of other areas of law, such as employment and privacy laws. An antitrust health check of whatever form has clear advantages for a purchaser. Detecting an infringement promptly post-closing enables the purchaser to control the situation by allowing it to terminate the infringement and possibly making leniency applications, seeking full or partial immunity from fines. Even if no infringement is detected, there are clear learning points from the process that help improve compliance efforts for the future. Health checks can also assist a seller as part of vendor due diligence, but in contrast to the position of the buyer, the pros and cons are more finely balanced. On the one hand, detecting an infringement allows the seller to control the situation and address the infringement, whether by making a leniency application or at the very least terminating the infringement if that is felt to be sufficient. It also allows the seller to preempt the risk of others, including the purchaser, detecting the infringement, leaving the seller exposed and defenseless. However, detecting an antitrust infringement can also complicate matters. Being on notice as to the existence of an infringement will doubtless result in the seller having to disclose against warranties and trigger a period of negotiation over warranties. This may affect the value of the business to be sold and could even harm the chances of the deal happening at all. While a seller will need to weigh the pros and cons carefully, the final decision may well depend on two factors: the risk profile of the business to be sold and the type of buyer. Where the business to be sold has a high risk profile, i.e. there's a real risk that antitrust violations may be lurking, and the buyer is sophisticated, such that it's likely to carry out a health check following acquisition, then it may be prudent for the seller to carry out the health check itself as part of vendor due diligence. The Commission's decision to target private equity shows that private equity firms must adopt the same approach as other corporate groups when it comes to antitrust compliance. We recommend establishing an effective compliance program which would include regular internal compliance training, conducting antitrust health checks, and, in appropriate cases, considering an internal amnesty program. We have considerable experience of carrying out health checks and setting up internal amnesty programs, and have a proven track record of successful global coordination of leniency applications. We look forward to discussing any concerns or any aspects around competition compliance with you.